Good afternoon, everyone, and welcome. We're pleased to have you with us this afternoon. We originally had 3 cases on the docket, but one has been continued, and we're pleased to have you with us. We will hear the cases in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes, and if you are going to have more than one appellant argue or more than one appellee argue, you'll have to share that time. The appellants do have the right to reserve up to 5 minutes for a rebuttal, so when you come to the podium after you've introduced yourself, let us know how many minutes you wish to reserve, and we will program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Dierdra Ransom et al. Versus Legends Bank.
Good afternoon.
Good afternoon, Your Honor. May it please the court, I'm Joe Wyatt. On behalf of the appellant, Dierdra Ransom, I would like to reserve 4 minutes for rebuttal.
4 minutes, yes, sir.
And I will not knock this off. About 15 years ago, I did. And it's the loudest noise I've ever heard.
Well, I'm glad you've learned something in this
Well, I did.
period of time. So,
thank you. This case is before you from the Circuit Court of Montgomery County, but has been assigned to Judge Joe Thompson of Sumner County, who heard the subject motions to be referred to here today, and also entered the order from which we have appealed. Just a little background, this case was first filed on June 15, 2018 in the Circuit Court of Sumner County. It was later transferred to the Circuit Court of Montgomery County on October 31st, 2018. There have been, in fact, many delays like that have pushed this case out further than it should have been.
now the Sumner County Court dismissed some of the real estate claims and then transferred the case to Montgomery County. And you're not appealing the dismissal of the real estate claims, if I understand that correctly.
Well, I would like to get back anything that I can, but I am appealing mainly the causes of action of fraud and breach of contract.
Absolutely,
like those
absolutely.
But yes, Your Honor.
Okay.
It was transferred over to Clarksville because Legends Bank is in Clarksville.
Okay.
The appellee filed 2 motions to dismiss for failure to prosecute. The first was filed on September 16, 2021, with a hearing set for October 4th, 2021. The pro se appellant at that time responded to that motion and appeared at the hearing, on the phone, that is. Counsel for the appellee did not show for that telephonic hearing that day. The appellant was informed of that by an assistant after about holding for 2 hours. After 10 months had gone by, the appellee filed what they called a renewed motion to dismiss for failure to prosecute on 25 July 2022, with a hearing date set for August 15, 2022. The appellant received neither the motion nor the notice of hearing, as she has testified by affidavit in the record. And in Judge Thompson's court, by the way, she was in fact put on the stand on a Rule 59 motion, which we don't see very often. In appellant's absence on August 15, 2022, the court did in fact dismiss appellant's entire case. And again, this was without notice to the appellee. She would have been there had she known of the hearing. I believe that's in line with the previous conduct, in this case, even acting pro se. As I previously...
But even had she appeared, what was she going to say? Because the case had been sitting still. Months earlier, a motion to dismiss for failure to prosecute had been filed. She, as you say, was on the phone for the hearing. It was continued, and yet still nothing occurred for another 7 months. And so what's there to say?
The only thing that can be said is that she had in fact responded to the first motion to dismiss, and she was acting pro se. Now I know the court doesn't hand everything to a pro se litigant, but the court does afford some deference to them. You look at Tennessee case law; it's replete with that very statement, in fact.
Right.
But she would have said, "Well, I'm waiting to see if I need to go forward, I suppose." But without the aid of counsel, she didn't do anything. That perhaps is a weakness in our case. Maybe the only one. I mean, the truth be told, we haven't got to the merits of the case. We're on these surface procedural issues. So that's what she would have said, Your Honor. That we would like to go on. I'd like to get another attorney involved. She probably would have got me earlier, had she known, or some lawyer. But that is what she would have said. Now, as I just intimated, this case is before you mostly on these procedural issues, as it involves several of the Tennessee Rules of Civil Procedure. And the trial court has yet to reach any of the issues alleged by the parties in the suit itself. The timeline must be understood. And so I just want to go over that just quickly. Appellant filed her first Rule 59.04 motion to alter or amend on September 19th, 2022, merely requesting a new hearing on that appellee's motion to dismiss. Certainly, the appellee objected to the same. The court denied the motion without a hearing on October 3rd, 2022.
Counsel, why shouldn't that be regarded? I know you have some language in the motion that disclaims that it's a second motion, but is there really a procedure for addressing that concern that you had with the ruling on the first motion to alter or amend, or the trial court didn't stay its decision, right? I mean, it's that decision. The clock's running from the date of the order. Why shouldn't we view this as a second motion to alter or amend?
I was ready for that question. I have never had to face this situation, but at this point, I was trying to do anything I could to get the court's attention to show the court what had been done. And we all know that a second Rule 59 motion is usually not allowed. And therefore, the second motion could have been denied. Could have been said, Mr. Wine, leave the courtroom. You can't file a second one. However, it was within that 30 days, that initial 30 days, that both, our hearing was granted by Judge Thompson and also heard. And I was very, very careful to be specific. At the hearing, when I told the judge, Your Honor, we have to appeal in 2 days if you don't give us a hearing on the first motion. And the judge says, I tell you what I'm going to do, Mr. Wine. In fact, those are his words. I am going to grant you a hearing. I'm going to set aside the first order, and I'm going to grant you a hearing on that first motion, the first Rule 59 motion. I believe that would have been a moot thing if it had happened 30 days after entry of the judgment.
But did the trial judge set aside the first order? Because in fairness to you, the language that the judge used is confusing at best. But in the very final order, the judge says the court's orders entered on August 25 and October 3 remain in full force and effect, which tells me that the previous order was not set aside. But again, in fairness to you, there was some language that you would have been justified to think, yes, it was.
Yes, Your Honor. And of course, lawyers draft their own orders, and then we give them to the court, and the court pretty much signs them if it meets the character of their ruling. Your Honor, I've never had to consult Rule 59.05, but we didn't get into the Rule 60 family because it had not been 30 days yet. It's a very fine point of procedural law that I'm learning from here in this case. And I don't want to be flippant or maybe seemingly arrogant, but whatever it took for the judge in the record, or maybe we would have written a letter to the judge, Your Honor, we ask you to please look at this, and of course copy counsel opposite, but whatever got the judge to, on his own accord, strike that original order is effective, it seems, pursuant to the rules, to give us a hearing. The first order said that he set aside his dismissal But I did see that there at the end,
So
the final order.
At that hearing, the judge seemed to verify that there was the correct address, and seemed to embrace the idea that it had been mailed properly. Where is the basis then for setting aside if this was mailed properly, if there's the right address and mailed properly to Ms. Ransom? Where is the basis for setting aside? Or am I misunderstanding what the judge's understanding of the facts were?
No, I believe he understood what was being told to him. And I practiced law with the lawyer that said he mailed it. And so if the clients received it, well, of course they ought to have their case thrown out. But they went to great pains, and I mean immediately when they learned of this, to try to recover from it, to hire me. And that was when I started on this path to, try to undo it. But we cannot prove a negative, I suppose. We have, Mrs. Ransom has sworn to the fact that she did not receive it. Now, the address that was given is the right address. Mr. Ellis, Attorney Ellis, said that he mailed it, mailed the motion, mailed the notice. My client said she didn't receive it. There have been, within the record, you'll see several addresses. She moved and she was staying in Knoxville for just a little bit. But she didn't receive it. She has sworn to that, both in her written affidavit and on the stand. She, for which she was not prepared, but I put her up there anyway. I let her go. And I said, we have nothing to hide. Tell the judge the truth. And so you have a transcript. It was important for me in these circumstances for you to have the transcript of all that occurred after that first order of dismissal was entered. I mean, I knew I had to make a record. I knew I wanted to show you what was going on.
Does she specifically state in that transcript that she didn't receive the motion to the, I guess, August motion to dismiss?
Yes. She, more than once, and I wrote the affidavit tightly to be sure that I illustrated that. But that is where we are, but I, as I said, nevertheless, the judge, within that 30 days where he does have the purview and he still has a hold of the case and it hasn't went over to Rule 60 or become a lost cause, he, on his own accord, his own initiative, sua sponte, set aside the order.
All right, let me, even though your time's up, I want to address a subject. If we get to the merits of your appeal, it appears that your brief is arguing that the complaint provided enough specificity to survive a Rule 12 motion for judgment on the pleadings. But if I'm reading the complaint and the claims appropriately, the only one that required specificity was fraud. The brief doesn't appear to address the merits of the dismissal of the other several claims. Am I missing something?
Well, perhaps, but more than likely it's just that I left it out, or maybe I didn't make it as clear. I doubt you missed much, Justice Clement, but we definitely want fraud and breach of contract back in there. There were a couple of federal claims that were rightfully dismissed as I looked at them. Okay. They couldn't be tried in state court, even though this is bank fraud being alleged. It's fraud and breach of contract that we'd like to really see restored in this case.
All right. Thank you. We'll hear from you on rebuttal.
Thank you.
Good afternoon, Mr. Nolan.
Good afternoon, Your Honor. I am Mark Nolan. I'm here to represent Legends Bank, the defendant, the appellee in this matter. And we would submit to the court, as through argument and through our brief, that the trial court did make a correct decision and that this matter should be affirmed. And so, briefly, because I know the court already has the argument, the dates and things like that, but the relevant dates are, the court heard the motion for failure to dismiss and granted it on August 18th, 22. If nothing would have happened, it would have been final in 30 days. The plaintiff filed a Rule 59.04 motion to alter or amend on September 19th. Within the 30 days, that's allowed by the rule. So now we're going to extend that because Rule 5904 is one of the few things that does potentially extend the deadline for filing an appeal to this court. That motion was heard, and if you look at the plaintiff's Rule 59, it says, as counsel just indicated, well, I didn't get notice of it. I didn't know. That's what the plaintiff says. So that's the basis for it. It also says that there was some outstanding discovery at the time. But basically, they didn't get notice. The court denied their motion, and an order went down on October 3rd of 22. So at that point, we now have a final order that must be appealed within 30 days. And this court and the Supreme Court have said repeatedly that those dates are really not flexible. So you file within the time period, or this court doesn't have jurisdiction to hear an appeal. But what we had here is there was the plaintiff now through new counsel who has come in at the end and has filed a second Rule 5904 motion to alter or amend, and that was filed on October 24th.
Counsel, let me ask a question about the characterization of this as a second motion, and there's some loose language back and forth in the hearing. This is not a second Rule 5904 motion on the same grounds as the motion decided by the October 3rd, 2022 order. Instead, this motion merely seeks an initial hearing on the plaintiff's September 19, 2022 Rule 5904 motion to alter or amend, which would be expected and held on any such motion. So by the language itself, and I understand the characterization, and there's even I think a reference in the transcript where it may be described as a second motion, but doesn't paragraph 4 make this a request within the 30 days where he's just saying, we'd really like, we understand, but you should have had a hearing on that. Let's have a hearing on that. And then the trial judge is saying, you know what, I should have had a hearing on that. Let me do that. Is it really a second motion to alter or amend, or is it a request for a hearing on the first motion to alter or amend?
It is a second Rule 5904. It's semantics that you can say we're just requesting a hearing, but you look at, and so let's look at the function of what happened, and if we look at the court on its own, when it said, okay, we're going to have a hearing, the judges have the authority under Rule 59.05. On the initiative of the court within 30 days of entry of a judgment, the court on its own initiative may alter or amend a judgment. But here, this is not on the court's own initiative. This is because the plaintiff has filed a motion to say, Judge, I want to have an argument. I want to present my side. So it's not on the court's initiative. Had it been, Rule 59.05 says, if that was the case and the court had done it, then the court must state in an order specifically its grounds for its action. So we don't have that. And so what we do have is Rule 59.01 that also says, because I was referring back earlier, when can we extend out that 30 days for that initial decision to appeal, and that you can file, among other things, Rule 5904, an alter to amend a judgment, which is what we had. But 5901 goes and says specifically, motions to reconsider any of these motions are not authorized and will not operate to extend the time for appellate proceedings. So we have a rule that is specifically on this that says you can't ask for a second. You can't raise your hand. What should have happened is when the first motion was granted, when the first motion was denied, that's when the appeal should have been filed. So we have instructions as to what should happen. And unfortunately, that they did not do that. They filed this second one. Now, there's and I cited in my brief, there are two cases that are on point on this. The Gasaway case, which talks about post-judgment motions, when two post-judgment motions are filed. The subsequent motion is void and does not toll the 30-day period on appeal. So as we have here, and as your Honor is alluding to, I also refer to the Grisot case, and I have probably not pronounced that, but it is in the brief. And it is similar to the question you just asked. That case determined that the successive Rule 5904 motion that requested a different relief than the first 5904 motion also does not toll the 30-day period for appeal. So both arguments have been put before this court before, and there's just not a second bite to say, I need you to reconsider, here's more information. And if you really look at what the plaintiff's own 59 motions, both of them say is, I didn't know about the first motion. That's what she says in the first motion, that's what she says in the second. So her premise as to why she should go in is the same in both of them. Now, assuming the court does find that she was timely, then now we get back to what does this court review anyway? And that is the motion to dismiss for failure to prosecute. What's the standard of review? It's the abuse of discretion. This court will only second guess a trial court when it finds that the trial court has acted unreasonably, arbitrarily, or unconsciously. So that's the standard what we're going to have to find. And you look back and you read through the briefs and the orders that were in the trial record. There's no evidence here that the court did those things, acted unreasonable, acted arbitrarily. The plaintiff was not prosecuting her case. And at various times she had attorneys, other times she was representing herself pro se, but representing yourself pro se doesn't give you a pass to still prosecute and move your case or to follow the rules or to do something. And we're not talking about a trick where the defendant's lawyer filed a motion and then 3 weeks later asked for some type of dismissal. We're talking about months and months and months that go by and nothing just happens. And so it takes over 4 years before the court actually gets around to finally dismissing the case. That's how much time had passed. So it was not a real short period of time. The plaintiff had plenty of opportunity to present the case.
Counsel, a procedural posture question. We have a number of claims here that are dismissed for failure to state a claim, right? They're dismissed on that basis. There are lingering claims then that there's no additional action on, and there's failure to prosecute and dismissal on that basis. Let's say you're right about failure to prosecute in this case, and the trial judge was right to deny the motion to alter amend. Does that take with it the earlier claims that were dismissed for failure to state a claim? Are they also part of this dismissal that stems from the failure to prosecute, or is those two separate things where you have only the lingering claims, there's dismissal as to failure to prosecute, or is it the whole case included? If you understand what I'm asking there.
Yes, Your Honor. Previously, the court had entered an order dismissing those real estate type claims. Of course, that order was, then there's a subsequent order dismissing the whole case.
Well, actually, there's 3 dismissals. There was the Sumner County order dismissing the real estate claims. Then it goes to Montgomery County. Then the court denied the motion to dismiss the FCPA PR claim or whatever you call it. I always get it backwards. But it dismissed the 4 or 5 of other claims. And then the very last order dismissed the remaining claims. So we've got really 3 dismissals. And so Judge Usman asked the question that I was going to ask, and that is, if we affirm the Rule 59 denial, does that wipe out all claims and causes of action for failure to prosecute?
For failure to prosecute, in our brief, we addressed the claims, and we explained why it was appropriate for the court to dismiss those claims for failure to state a claim.
Right.
And there was no response by the plaintiff that refutes or changes our analysis of why the court, again, were they appropriately or did they act unreasonably? And the court acted reasonably in dismissing those claims for failure to state a claim. Mm-hmm. So, yes, there were different times of different parts of dismissal, but at the end of the day, the court acted appropriately in ruling on those various things.
But the question is, do we have to address those other claims individually, or do they also fall because of failure to prosecute? Because failure to prosecute is failure to prosecute the complaint. And the fact that some of the causes of actions were dismissed along the way, you still have a failure to prosecute at the end of the day.
Right. And I'm not aware of a case that would split that when the court dismisses the lawsuit for failure to prosecute, that it somehow leaves hanging cases it previously dismissed for failure to state a claim.
Let's get back to the Rule 59 motion. As Mr. Wyant said, 2 days were remaining on the 30 days to file a notice of appeal when he was standing in front of the judge saying, we'd like to have a hearing.
Yes.
And the judge, the language was inartful. It was going to be my language. But said, okay, we'll have a hearing. Did an order go down within those 2 days?
The order
saying whatever the judge said?
It went down. Oh, well, and I have that.
Yeah, I've looked at my papers and I can't find the order that I'm referring to, and which is why I'm asking you.
It would be, I think, on record, page 414, order granting hearing on plaintiff's Rule 59 motion.
And do you know what date that is, or?
That would be November 10th of 22.
Okay, thank you.
So, Judge, I am obviously about to run out of time, so.
And the order denying the Rule 59 originally was entered on October the 3rd?
Yes.
Okay, thank you.
Yes, Your Honor. The one other thing I wanted to point out, under Rule 5904 in case law, what generally 5904 is when the motion, when the appellant, when the filer of the motion is showing that there was a change in the controlling law, that there was previously unavailable evidence that's now available, or that we're correcting errors of law or to prevent injustice. None of those bases were cited in either of the plaintiffs. So generally, they didn't even state a reason as to what normally you would see that rule, the 59 for. And so just in conclusion, Your Honor, I think that the appropriate remedy here is to affirm the trial court's orders and dismissal, whether it's to failure to prosecute or for failure to state a claim. Thank you.
Thank you, Mr. Nolan. Mr. Wyant?
Yes, Your Honor, I would want to address what you just brought up. The reason that it was taking several weeks to get an order entered is because of the procedure for interchange. But I just want to read something. At the October 31st, 2022 hearing, the court granted a hearing on that original September 19, 2022 Rule 59.04 motion. It is vital to realize that the granting of this hearing on such motion was made in open court, as the court just mentioned, 2 days before the appeal deadline for the October 3rd, 2022 order. During the hearing, like you say, I'm standing right there before him, and he says, and I tell the court, we have to file a notice of appeal here in 48 hours if you don't change this. And that was when the judge looked at me and said, all right, Mr. Wyatt, I'm going to give you a hearing, just like that. I remember it. And this case really tests Rule 59.05 itself, and whether the rules mean what they say. There's not a lot of case law on Rule 59.05. I think I'm going to make some here today. But it was within the court's purview for the court to do something, whether it had been by motion, letter, conversation in the hall, or in chambers with counsel. And the court took it upon itself to sua sponte do it. The court could have said, when I filed my second Rule 59.04 motion, no. The court could have said no to allowing a hearing on it. But the court said yes to a hearing, and then, of course, the aforementioned dialogue occurred.
Counsel, opposing counsel referenced Rule 5901 and the language, motions to reconsider any of these motions, and that includes referring back to 5904, are not authorized and will not operate to extend the time for appellate proceedings. Even if this is not a second motion, but a hearing on the judge's ruling on the 5904, how can we characterize it anything other than reconsideration of the judge's October 3rd ruling? And doesn't it have to be a seeking reconsideration?
As I said, and that's hence the language that the court quoted, this is not a second Rule 5904 motion. I was trying to make it clear that I was simply seeking a hearing on it. And the court could have just summarily said, no, we're not having a hearing. When I said it, just called counsel and said, no, we're not going to have a hearing on this. It's a second Rule 59. But the court not only entertained it, but changed its mind. The court changed its mind at that hearing when I still had the chance of a notice of appeal, and I relied on the court in not filing the notice of appeal, which would have brought me right here anyway. But I relied on the court. I'm not saying it's an estoppel issue yet, but I believe that term should be looked at. But I was doing all I could, and the court allowed me to have the hearing. It was a lengthy hearing, and of course the court has a transcript. But I would like to say, finally, that Ms. Ransom has done all that she could to push the case along. She's not an attorney. COVID happened during this time. The case sat in their own county for a while. Then it sat in Montgomery. I'm saying before Judge Ross Hicks for several months before he recused himself and sent the case over to Judge Thompson. There's just been delay after delay, and it makes her look bad in some respects. But once you see the record, you'll see what I mean. There are large delays of time that I'm not used to.
All right. Thank you, Mr. Wyatt and Mr. Nolan, for your arguments. We'll take this matter under advisement.
Thank you.
Excuse me. We have to take a very short break to change the panel. We'll be right back, so please don't leave.